Welcome to the Wills and Estate Transmission Podcast, brought to you by De Groots, specialist lawyers in wills and estates. Hi, I'm Max Williams, Special Counsel at De Groots, and in today's episode we'll be talking all things estate planning. And today I'm joined by my co-host, Tony. How are you, Tony?
Hey, I'm very good, Max. Thank you very much. And we've got some questions that have been submitted from listeners and viewers, so we'll jump straight to those. And of course, the first question is, what does an estate planning lawyer actually do?
Well, estate planning is a specific area of the law, and what it's concerned about is planning how your estate, which is all your assets that you own, is going to transfer or pass to the various people in your life when you pass away. And so as an estate planning lawyer, we have to understand your estate firstly, what it consists of. And your estate may consist of more than just traditional types of assets. So it might be more than a house and some money in a bank account. You may have superannuation. You might have an interest or a controlling interest in a family trust or an operating or investment company. There may be various different types of assets that require a different approach, and as estate planning lawyers, our job is to look at all of that and give you advice as to how to ensure that those assets and that wealth passes to the people that you want it to.
Okay, so I just thought of something. What about cryptocurrencies that go up and down in value all the time?
Cryptocurrency is an interesting one, Tony. The issue with cryptocurrency is to access it, you require an access code or a key. And there have been cases where the person who owns the cryptocurrency has passed away without revealing or passing on that critical information to access it. And without that critical information, the person's next of kin can't actually cash in the cryptocurrency, and therefore, for all intents and purposes, it's worthless. So it is an interesting issue in estate planning at the moment as to how to safely ensure that those access codes or access PIN is passed down to the appropriate person without someone perhaps intercepting that and using it before the owner passes away. But that is something that the owner will need to give due consideration to, how to pass that information on safely.
Well, I use a keyword manager or password manager. And from what I know of crypto, yes, I have dabbled in it. So you can have a cold wallet password to get into the cold wallet that you could potentially save in the password manager and then give that key to your lawyer?
No, you wouldn't give it to the lawyer. We wouldn't want that. But you would perhaps give it to someone else that you trust. But there is a risk there because whoever you give that to, if they access it, they may be able to, cash it in or trade on it without the owner's consent.
A tricky little topic.
It is tricky.
So the next question is, what's the difference between a will and estate planning?
Well, a will is a legal document that passes ownership or transfers ownership of your assets to beneficiaries when you pass away. Whereas estate planning is a much broader consideration, and it will encompass the will, but it will also, or may encompass, other types of documents. For example, you may need to have an enduring power of attorney that deals with your assets if you were to lose capacity. You may require documents to deal with your superannuation. You may require documents to be prepared that deal with any family trusts or companies. So that will isn't necessarily going to deal with all of your assets. And that's where the estate plan comes in, to make sure that all of your assets are taken into consideration. However, an estate plan is not just about your assets. There can be other considerations that need to be considered by someone who's undergoing estate planning. For example, you may need to give some consideration to who will take care of your children if they're under the age of 18, if you were to pass away. Or you might need to give some consideration to what would happen with certain trusts that you have interest in. So the estate plan doesn't just consist of your assets, it's also about providing for the people in your life and making sure there's documentation to document that.
Okay, so you touched on children now in different definitions. So children until 18, under health funds and other things and government and what have you, it can be up to 25. So will that make a difference?
No. So what we're talking about here is guardianship, which is who's legally entitled to look after the children while they're minors.
And the next question is, when do I need a will?
Well, if you own assets, then you really should have a will, because the will is your way of ensuring that your assets go to the people you want them to. If you don't have a will, then we have something called the intestacy laws, which is where the government in legislation sets out who they think your assets should go to when you pass away. But a will is really your way to ensure and control where your assets go. Now, of course, the rejoinder may be, well, I don't have any assets, or I don't have any significant assets. But I think there's two things you should consider. One is superannuation, which I find a lot of people tend to forget about because it's not money in a bank account. They don't tend to think about it all that much. But you might not technically have much. You might not own many assets, but you may over time have accumulated quite a substantial superannuation balance. And if you don't have any children or a spouse, then that superannuation is going to have to come into your estate, and therefore you're going to need a will to deal with it. Secondly, you may not own much or you may not have significant assets, but you may have children, young children. And a will is a really important way to ensure that the people you want to raise your children actually take on that role. We call that guardianship. So your will can also, in addition to appointing an executor, in addition to transferring or gifting assets to people, your will can also appoint someone to look after your child, otherwise called a guardian.
Yeah, I think lots of people are quite lazy. I'm one of those people. In my superannuation, I don't have a named benefactor for my superannuation, but of course I do have a will. So also the same for children. I think lots of people forget that with children, they should automatically go to the grandparents, but what happens when the grandparents have passed away?
Well, that's right. Or what if the grandparents aren't suitable, or the grandparents don't live nearby? I mean, I tend to find that one of the main priorities for parents with young children when it comes to providing for guardianship is trying to appoint someone who's going to maintain a reasonable level of stability for those children if both parents were to pass away. So making sure that they still live in the same place, they still go to the same school, they can still see all the same friends, rather than having to be, whooshed interstate or taken overseas. And so, grandparents may not be the best people for the job. It might be close family friends, might be godparents, might be siblings. Doesn't have to be grandparents, and it's certainly not automatically grandparents.
Okay, so let's have a look at a topic that everyone thinks about. You see all these ads and different things about doing your own will, when you get will kits and you get a will kit in a newsagent and things like that. So can I really do my own will, and can I do it with a will kit?
Well, the short answer is yes, of course you can do your own will. There's nothing legally to stop you from doing that, and of course many people do. The problem is you could ask, can you do your own brain surgery? And the answer is you probably could, but it's not a great idea. And so similarly with a will, yes, you could do it, but I think that's a very risky enterprise. A will, first of all, has specific legislative requirements in order to be valid. And even if you get those right, there's still specific wording and ways of passing down assets that estate planning lawyers are very trained in, but your average person on the street who hasn't been trained in estate planning is just not going to know these things. And so they may write a will where in their mind it's very clear as to what they want to happen. But we see this often when they do pass away, there's a dispute because it hasn't been worded properly or they've left something important out. And so I just don't see, when you think about how much a will usually cost compared to how much it would cost your estate if it becomes litigious and people want to dispute it, it just seems like quite an insignificant expenditure to ensure that your wishes are carried out. So yes, you can do your own will, but our advice is you should always see a specialist.
Now, I've got a will and there's maybe some of the people I've left some items to I'm no longer in favour with or have moved away or moved overseas or passed on or what have you. So how often should you update a will?
Well, we say as a general rule of thumb, you should review the will once every 12 months. So on the anniversary of when you made the will, get it out, have a look at it and make sure that it still reflects your wishes. What you don't want to do is set and forget, which sadly many people do. Now, having said that, just because you're reviewing it once every 12 months doesn't mean, of course, that you need to change it every 12 months. You only need to change it if that document and the wishes contained therein no longer reflect your actual wishes. So, for example, if you have had a falling out with a beneficiary in the will, or maybe they've died, or maybe you've changed your assets, or anything where there's been some sort of change in your circumstances, that may warrant actually updating the document. Again, as a general rule of thumb, I tend to find, based on how frequently people will see me, an average will last 5 to 10 years because that tends to be when big life changes happen, whether you get married, have kids, get divorced, buy a substantial asset. They all tend to happen in 5 to 10 year increments, I find. Maybe more, maybe less, but just sort of as a rough average.
And would it be a good tip to tell people where the will actually is?
Oh, absolutely. There can be quite significant consequences if an original will is misplaced or lost. So for that reason, certainly our clients, many people will deposit their original will with a law firm where it's kept in safe custody. And they, of course, get copies of it. But that way they know that if they move house several times, the original will's somewhere safe. From time to time, and particularly where people may have made their own will, they will keep it at home. But as I said, there's a big risk there because if that gets misplaced, there is actually a presumption at law that where an original will is lost, that the person who made the will actually intended it to be revoked or cancelled. So it's much safer to deposit it in, professional safe custody facilities.
So we're talking about original. Okay, so which version would apply, and do you have to make sure that you destroy the previous version?
Well, the original is the will that's got the ink signature of the person who made the will. Unfortunately, at the moment, it's not possible to make a will with DocuSign or similar facilities for electronic signing. Wills still require, for it to be formally valid, an ink signature from both the person who made the will as well as the witnesses. And so the original is simply the document that contains those ink signatures. In terms of previous versions, if you update, certainly our practice is always to keep the originals of previous wills, even if they've been revoked, because it does give an accurate record of what the will maker's intentions have been over time. And where the will may be contested in the future, that can be useful information. Now, of course, if a person who's made a will wants to completely destroy it, even though in their new will they've revoked it with the relevant clause, then they can do so, but our practice has always been to give them the original and they can go and destroy it if they wish.
Okay, so I'm young, I don't have lots of assets, or even if I'm older, I've got particular things I want to protect and care for. Can I leave my will and my estate to my cat?
Well, In Australia, the short answer is no. A cat, as much as we may love the cat or the dog or the goldfish or whatever pet it is, legally they are not considered a person. They are considered, and it doesn't sound particularly sentimental, but they're considered a chattel, much like a chair or an item of jewelry. And so you can leave your pet to someone in your will, but you can't actually leave anything to the pet because they don't have that legal personhood. So usually in that situation where someone does have a pet and they do want to provide substantial funds for the maintenance of that pet, there is a special way to do it. The best way is to set up a trust where you leave the sum of money for the benefit of the person who's taking care of the pet, and you build in certain conditions to ensure that the person who's looking after the pet is, maintaining the pet and making sure that the pet is still alive. But other jurisdictions, there's some interesting Netflix documentaries about overseas situations where they obviously don't have those restrictions around leaving money to pets, but certainly here in Australia you can't do that.
Yep, I've definitely seen that Netflix show. It was if anybody wants to find out more, go right ahead.
Thanks for listening today. Don't forget to subscribe, and if you require any further information, please go to our website, www.degroots.com.au, and book a consultation. The contents of this podcast do not constitute legal advice and are of a general nature only. Listeners should make their own inquiries about their specific circumstances and seek legal advice.